One of the things that's required in most of your mortgages, again, you'll have to look through the mortgage, or your attorney will look through the mortgage and know certain lenders require it. What is called a notice of intent to accelerate, or a notice of default, acceleration notice, one of those things. It's required in most mortgages, and what it requires is that they send this letter. They, the lender, send a letter to you notifying you of not only the default, but that they can accelerate the sums if it's not cured.
Correct.
Usually it's 30 days. Again, every mortgage is different. Make sure your attorney looks through the mortgage.
And reads it.
Right, reads it.
That would be nice.
So this is one of the what we call affirmative defenses. After the motion to dismiss, if that's granted or denied, when you get to the point of responding and you file an answer in affirmative defenses, those are the things that your attorney has found the defects in the plaintiff's case. They need to prove their case. And if you bring up an affirmative defense, they need to be able to refute that. So one of the things that's important is that notice of default, notice of intent to accelerate. If it is a condition precedent, meaning it needs to be done before they can file a lawsuit in most cases. And in a lot of cases, people don't get the letters. They don't get the notices. You may get letters constantly once you're behind, saying you're behind in your mortgage, you're behind, we can help you, do you want a trial mod? This is totally different. This is, like I called it, a notice of intent to accelerate. So there's good case law that came out in 2011, and from our local courts, which is fantastic. And in those cases, not only, once you've raised that issue as an affirmative defense,
right,
we call it, once we've raised it, they, meaning the lender, needs to refute that. They can't just do that by showing a letter saying, we sent this to you. Okay, they do that a lot. That's not gonna work.
I got it.
Because again, and it'll be like on a blank sheet of paper,
right,
and addressed to you, and this
with
is
no
a letter.
date.
Right, no date.
No date.
No,
we sent it.
no letterhead, nothing.
Right.
What we talked about with the verification, this all ties in. It's called authenticating it. They need to authenticate that letter has been sent. So somebody with the knowledge, which is again why it's important to do discovery,
right,
videotape depositions that
yes,
Carmen loves to do. It's important because they likely don't know that this letter was sent. And so that's one very important issue that your attorney will want to see. But we've had the case law on our side in 2011. Mm-hmm. They need to authenticate it somehow. They can't just give a document and say, well, there's the letter, we sent it. So it's a very good thing for homeowners that came out in 2011.